Of course you can. Yeah. And if we can go ahead. Are these off? Hey, Mr. Chairman, how do I turn these on? Will you flip these on? If we can go ahead and take our seats, we're about to get started. I don't know. I'll ask it. Thank you. I totally agree. Adding those both to my list of questions. All right, if we can take our seats, we're going to go ahead and get started. Thank you very much for keeping it to the appointed time. 13-minute, 10-minute break, kind of like the questions. So, Representative Fettgetter, you are recognized. I do want to make an announcement, and I don't think he's in the room, but he's coming back. Representative Dollins from South Oklahoma City is in the room. Was in the room and is coming back. He is a representative. While he's not on the committee, I'm going to allow him to ask questions when the committee members are done. If there is another representative that is here or senator that is here and has a desire to ask questions, if they will text me. I think I have the most widely available cell phone number on the planet, but if not, just come see me. And with that, we are going to go ahead and move forward. Representative Fettgetter, you are recognized.
Thank you, Mr. Chairman. Thank you, gentlemen, for being here today and helping us to work through these issues. I want to start off by a comment that was made a little bit earlier about, our schools should be palaces, and there was a question about the off-the-top money. I completely agree that education funding is critical in our state, and I've fought, for the past year and a half to make sure that we did do that. We got the funding headed in the right path. But I also want to bring to attention that it was also mentioned that there's a lack of trust in this legislature. Part of that lack of trust comes from state question initiatives that have promised to fix our education problems and failed to meet that goal. And so that's why you hear Representative Roberts talk about the need for the legislature to have a little bit more control over the dollars that come in so that we can do our job as legislators that we're elected to do, which is appropriate the dollars for agencies. So I just kind of wanted to start there because because you were very passionate about it, and I appreciate that passion because I have that same passion as well. I want to start off with a question. I understand that there are states that, and this is going to deal with the commerce side of things, there are states out there that have unlimited grow operations and dispensaries and those types of things. When we look at Oregon, for example, you have nearly 1 million pounds of flower or medical marijuana that was grown that was not able to be sold. And so how do we take that type of, how do we keep from feeding a black market in a situation where if we have unlimited operations and licensing, how do we keep that from feeding a black market? Because people that have a lot of excess could potentially start selling that on a black market over state lines, those types of things. I'm just curious.
So Chip Paul, Oklahoma Health. I'll start. I'm sure we'll all have a lot to say about this one. But again, when we did this as an initiative and a movement, it was a principal tenet, really, of 788 to not only provide this as a medicine, but also to provide this as a business opportunity for Oklahomans that wanted to get in the business. Okay, so and that is why we didn't limit licenses. And you bring up Oregon, but let's talk about the disasters, okay, really. And let's talk about New York and Illinois and Ohio and Arkansas and Florida and all these other states that really have done this. They've tried to limit licenses. And here's the problem that you run into. And again, who's going to be the expert here? Senator McCourtney, or are you going to decide whether my application's better than Mr. Durbin's? And, what criteria are you going to use to do that? So this is the problem that most states ran into, and this is the very reason why we did not want to do this, because it creates this situation of, either who has more money, who has a better plan. You know, there's some situation of selection that has to go on. And when you have that kind of selection, now you have to have a lot of preparation. And again, I think in New York, it cost you literally $1 million to be able to put together the package to be able to file for a license, right? I think it was, you know, you had to show $50 million of wherewithal and things like that. So we very specifically and with high intent do not want to create that situation here in Oklahoma, okay? So that leads to another question. How do we protect the little guy? And again, I think that's a whole nother question. The way that that's been done in other states is with temporary canopy limits. So if you say, like, for growers, we're going to only let you grow 20,000 square feet, and we're going to put a cap on that. That prevents big money, you know, from coming in and doing 100,000 square foot grows. And that's really the situation that you have in Oregon. So you have a lot of big money that came in there that really, you know, built a bunch of big grows and caused an oversupply situation. But really in every other state, it's been kind of the opposite, where they've tried to limit these licenses. They've run into a lot of problems. And, you know, Arkansas is just a classic example, right? It's just a hairball. But, you know, that's what they did there. So we decided to do it different. We think we learned a few things, you know, watching people over the years. So that's kind of why we did things a little bit different. But, yeah. And apologies to you, sir. For last time, I was nervous, and so I was a little abrupt with you last time, so I apologize.
No worries.
Chris Moe with Green the Vote. We would have a problem with limiting the number of licenses. We would also have a problem with limiting the plant count, but we would not necessarily have a problem with limiting the canopy size. So we see a way to keep out the big business, as he's just mentioned, and help the Oklahoma grower without decimating 788.
Ron Durbin, Green the Vote. If I could just add something there, you know, one of the things with the idea that you're going to have an oversupply, when Colorado first instituted their medical program, I think a pound of flour was going for, you know, close to $5,000. I think the last report that Colorado released, the average price per pound was about $850 a pound. So you're going to have market fluctuations. This is an agricultural crop. And you're going to have, you know, bountiful times, and you're going to have times where you might not have as much supply. But what we have to remember is that this is passed for medical purposes. And so as the price goes down, the cost of the prescription for the patient, or, you know, and them to get the medicine that they need goes down. You're going to have a similar situation to where you had the vapor shops when that became a very popular thing. You're going to have people get into this industry that think they have everything solved, they have all these problems solved, they can make a fortune. They're going to fail. But that's part of the process. That's part of the process we want to encourage, because those people who do it efficiently and those people who do it well and grow a superior product are going to be the ones that continue to thrive and grow. And the ones that aren't doing it well, that aren't managing their cash well, are going to fade and be subsumed by the market. That's an okay thing to have happen. So restricting the amount of grow or the amount of product that can be grown by anybody is going to sort of subvert the market. And I think that creates all kinds of unintended consequences. Let the market dictate who should be in the market.
Representative Fatgetter, thanks for the question. Bud Scott, New Health Solutions, Oklahoma. I think the original question is, how do we address oversupply? And how do we address the issue of having an abundance of Schedule I narcotic out on the market? And that's a very real issue. Under State Question 788, there are no limitations. There is no enforcement mechanism. And I think what we're ultimately talking about here is, do we have projections? Do we have analysis on what our projected consumption rate will be here in Oklahoma? What will patient demand look like? Our organization has algorithms based on this that really determine, based on what we've seen in other markets, comparable medical markets. Now, Oklahoma is going to be a little bit different because it has no qualifying conditions like many of these other states do. But we're looking at a demand market somewhere in the range of 500,000 ounces per year. And at that point, you have X amount of production that can meet that demand. So each square foot of production will have such a produced amount. And then what do we do beyond that? So if we're projecting a 500,000 ounce demand for patient demand here in Oklahoma, but we're producing 6 million ounces. What do we do with that product? And I think that's something that we do need answered.
Thank you. Secondly, when we talk about legal limits, I've heard it said that the legal limits in 788 was a 30-day supply. And I've just seen this, on social media, talking to people, in my district, different places. I'm not saying you all have necessarily said that, but I've been told that the legal limits in possession were a 30-day supply. I'm just wondering if you agree with that, and if you could explain, if you do, how do you determine that 30-day supply? Who is making that determination?
Isaac Cavanis, Green the Vote. That's kind of the beauty of medical cannabis, is that everybody's 30-day supply is going to be different. And so that limit was very specifically set where it was set so that everybody would be able to have their limit. Obviously, if you need less than that, you're not going to go out and buy that maximum amount. But it's not our job, or necessarily even your job, to tell a patient how much his 30-day supply should be. It should be back to the doctors talking with their patient about how much cannabis they should be using. And so the limit set forth in 788 allows that flexibility for somebody to use the amount that they need.
So if I may respond just directly to your response. So you're saying that it's not my job to determine that, and it's not your job, but you all helped create 788, and you put these limits in there, and it's being said that this is a 30-day supply. So my question is...
788 doesn't say it's a 30-day supply.
No. I'm saying, that's what I said. I said it's being said that that's the number of ounces was determined to be a 30-day supply. So my question is, are you telling me that the doctor will say you only need X number of ounces per month, or does everyone allow the total possession limit?
I'm telling you, by the law, everybody would be allowed the total limit, but if a doctor is doing his job, and as a patient, if you're dealing with your doctor the way that you should, that doctor should be going over the amount that you're consuming. Otherwise, that doctor's not doing his job.
Okay.
So Chip Paula, Clemens for Health. Those limits were hotly debated. DPNROK, you might recall, those limits being debated, when we were writing that. Okay, so there was a lot of discussion that went around those limits, a lot. Okay, so where we finally landed on a decision, and then what we actually put in the law or the proposed, was this rationale. So what's the worst case scenario that we could think of, the worst patient scenario? Who would need the most? Okay, and we went to the cancer patient. And if you look at cancer protocols with medical marijuana, they suggest about a gram of oil a day. So that's where the 30-gram supply came from. That's a 30-month. And again, I'm the one that was saying 30 days. Okay, so I've said that a lot.
Okay.
But basically, that's the rationale. Was what do you need for a 30-day supply? Again, what's your standard prescription? It's 30 days. So what do you need for a 30-day supply in the worst case scenario? And then how does that translate to ounces or plants? So those are exactly where all those numbers came from.
Done.
But the thing that we did probably not do properly is it should have been and not or. Again, we probably as patients, we need to be granted some rights to hold certain amounts of flour, concentrate, or edibles in a mixture, but the intent there wasn't or ever.
So I'm out of time, but I have just a real quick response. But it's my understanding, correct me if I'm wrong, and I'm not trying to be argumentative with this stuff. If I get a license, that license is for 2 years, and that means I can go to any dispensary during that entire 2-year time frame and purchase up and possess the maximum amount allowed by the law. Am I correct in understanding that?
So let me ask for, Chip Paula comes for health. Let me ask you for clarification on your question. So if you go in a dispensary, you can, and this is going to be stuff that's going to need to be fixed, honestly, but you can go in and buy 3 ounces, but if you travel with it in your car, you're kind of exceeding, the ounce and a half thing, right? So I think we need some clarity there. But are you asking, could you go to dispensary to dispensary to dispensary and buy 100 pounds, just buying it 3 ounces at a time? If so, that absolutely is, the intent here is to have a medical program. It's not to provide a sneak around the black market or anything like that. We really are, sincere in our hope to do that.
Okay, thank you.
Thank you for your questions, Representative. At this time, I'd like to recognize Representative Rosecrans for questions.
Well, thank you all for being here. I'm State Representative Jacob Rosecrans out in Norman, Oklahoma and Noble, Oklahoma. I've met many of you, and the kinds of questions that I have, I'm extremely open for all kinds of questions from my constituents and everybody else from around the state. So what I have here is there's no way we're fitting it within 10 minutes, flat out. So I've kind of had to prioritize. So realize that this is kind of my questions along with some very, very, very concerned citizens' questions as well. And it's open to the whole entire panel, and I will try to be fast. Some of these are pretty intense. Let's go ahead and start with what was the thinking behind prohibiting gun owners from having a medical marijuana license?
Ron Durbin, Green the Vote. That is an absolute fallacy of reading of 788. That's a federal guidance from the ATF on ownership or purchase of a firearm from a licensed FFA dealer. That is not in 788 in any iteration, nor any reasonable interpretation of the widest boundaries that you could find in 788. That is a federal issue, not an issue that we could deal with, or we wouldn't be trying to take guns from people. If you can't tell, I think everybody up here is pro people's rights.
I'll cut in real quick. That one, I kind of expected that answer, but I really was looking for some clarification because it came up a lot. Obviously, maybe some people need to read 788 a little bit closer. I agree with you. I'm going to move on to my next question. Does the panel agree with that?
Yes, ditto, absolutely. We have a constitution in this country. We have a Second Amendment. You cannot take away, under certain conditions, I guess you can, but no, that's sacrosanct. So it's good luck trying to take my guns away. Seriously.
Thank you, guys.
Representative Rosecrans, we actually have specific language in our proposal that spells out state protections for firearm ownership and the right to bear arms. So we just re-emphasize that specifically within the statutory proposal.
Thank you very much. My next question, let me look through here. Some of these are very specific, even this one. I really like this one. Let's go with, so we're assuming there's established medical history that backs up the request for a card. As I understand it, and is said, 2 doctors would have to sign off for a patient not yet 18. So the question, I have a twofold question. First, so both doctors, do they have to have an established history with the patients? Example, primary care physician and a specialist?
So Chip Paul, Cummins for Health. I'll tell you, as we were drilling, again, all of this, we circulated a very sort of not a law that needed to be regulated, right? It needs a lot of detail, and that should come in regulation. So in discussions with the Oklahoma State Department of Health, what we talked about was absolutely that at least one of those physicians had to have an established relationship with that child. The other thing that we thought was appropriate to specify is that one of those physicians needed to be a pediatrician. But we were way more specific in that, and we get that. When we're dealing with a child and medical treatment of a child, that needs to be specific and well-defined, and I think everybody agrees with that intent. So
the rest of the panel agreed. Okay. So, and the second part of this question is, if established patient-doctor rapport must be set out, but one or both do not consent, because either they disagree with a parent or they do not feel ethically okay consenting to a minor, or they work at a hospital that has publicly spoken out against 788, even though it now is the law of the land, what rights would a parent guardian have to contest the refusal?
Well, Ron Durbin, Green the Vote, they can also go seek alternative advice and create and establish a relationship with a different doctor. Just as any patient nowadays, if they don't agree with the advice of their doctor or don't think the doctor has their best interest at heart, they can seek a second opinion. We're not restricting that in any way and would encourage anybody that believes that to be the case to go seek a second opinion or a third opinion to get the medication that they think they need and to try different strategies for treating whatever illness it is that they have.
And Representative Butts-Scott, New Health Solutions, we provided specific language on protecting the right of a physician to not have to make such a recommendation, but also spelling out how that recommendation process would actually operate.
Very good. I'm going to kind of, just to clarify too, once again here, this is going to be kind of all over the board because I'm kind of picking and choosing off of a very extensive list of questions that I had and that came up. I'm a former teacher. Today's the first day of public schools in Oklahoma City Public Schools, so it's the first one I've missed since 2012. There has been so much concern from teachers and from parents about how we're going to look at this through the eyes of public schools. I have answered many questions because I kind of know that it's actually going to be up to it's medication. It's going to be up to the doctor and the patient. Am I far off on this?
Ron Durbin, Green the Vote. I'm a former teacher. Before I went to law school, I taught 3 years in high schools. So I certainly understand the concerns that teachers would have in this area. But it is a medication. It is a treatment. There are already restrictions on how schools deal with medications, on what the reporting requirements are, the doctor requirements, the dispensing requirements inside schools. And I think a school can come up with a system for implementing something that works within these guidelines if they put their minds to it. I don't think there's any reason why they wouldn't be able to do that. One of the concerns I've heard and we've heard is, about smokable form. Well, you can't smoke on a school campus as it stands now. So that's not really a way that a parent could get the medication to their child. There are alternatives to that. The child can be taken off the school grounds if in the parent's guidance to take their medication if that's the only way that they can be delivered it. But there are so many alternatives for how to dispense this wonderful medicine that there's a solution there for everybody. It's just got to be on an individual basis, and it's got to be for the schools to work with the parents for that.
Very good. I agree with you on that. Oh boy, I've got a very, very, very impressive question. I think a lot of these can be answered. I'm just going to throw it out there by a regulatory agency. I'm sure that's what we're going to have to do. And this is my opinion as a legislator and as a parent and a concerned citizen. Let me go with this I think we're running out of time here pretty quick, but I work very closely with people with disabilities, and they are extremely concerned about the cost of the medication. Could you kind of make them feel a little bit better? Will there be some type of insurance protections or will Medicare, Medicaid? I just really need some clarification on that type of thing.
So Chip Paulo, Clements for Health. Again, some of those are federal issues, right? Insurance. And one thing that I would encourage all you lawmakers to do is pay attention to what's going on in Washington right now and at the federal level with the Senate bill. Again, the Senate bill was introduced by Warren and Booker, I think, but Trump is supporting the bill. And that imbues a lot of rights back to the states, banking rights. I don't know that it necessarily extends to insurance, but again, that's a very important question. One of the things that, came up here about really canopy limits and things like that, while it sounds benign potentially to your question, it inures to your question, meaning that will determine pricing, market. And one of the things, marijuana is very expensive. If you're a patient, it's expensive. It's expensive right now. So what's the proper line between industry, success, and access to patients? That's sort of a market thing, but that's a thing that, when we make these decisions about market caps and things like that, it has impact. So, yeah.
Isaac Havness, Green the Vote. Again, we referenced this earlier. I think that will be an excess of product available on the home grow side that I would hope would be able to go into some sort of charity program to help people who may be in this position where they can't afford their medicine. I can tell you from a business owner's perspective, I own a CBD store in Tulsa, and our products range anywhere from $12 to $450. And I had a customer come in that specifically needed the $450 product. I tried to figure out any way possible to not sell them this product because of the price, and he looked at me very clearly and said, my copay is $3,600 on my current medications. If this works, you've just saved me a ton of money.
And Bud's got New Health Solutions. I think that's a great point, that if you look at the cost of other medications, the comparative cost for cannabis-related products in other jurisdictions doesn't even come close to the cost of those other medications. I'd say I think you can look at most communities that have an implemented medical marijuana program. I can't think of one state where the price for cannabis in any of those states is too high, quote unquote, for most patients to afford. Now, there's case law that's coming out right now on this issue. Out of New Jersey, there was just a case that was issued that effectively said that the private employer had to cover, through their insurance, they had to cover the cost or reimburse the patient for the cost that they had expended on this product. However, that was a very extensive case. So I think this area of law is developing kind of day by day. So we can't force companies to cover the cost of reimbursement right now. Medicaid, Medicare, obviously it's still Schedule I federal narcotics, so it cannot cover that.
Chris Moe, Green the Vote. I just want to give you some numbers from an actual patient perspective. 3 years ago, my medications cost around $900 a month. Those are opioids and all kinds of other mood enhancement drugs, almost all of which I've replaced with cannabis illegally. Runs me around $500 a month. When a dispensary opens, it will probably run me around that same amount. This is why the home grow is so important and why not limiting the number of licenses is so important. I understand canopy size will affect price too, but if we have enough businesses out there, I don't care what you limit the canopy size to, we'll have enough. And the price is extremely important because I've been to other states. I know what it costs. I know that me surviving on disability, I would not be able to afford it if I could not grow it myself.
Thank you, Representative Rosecrans, for those questions. And at this time, I'd like to recognize Representative Loring for questions.
Thank you, Mr. Chair. I want to thank you all for the open conversation here. Let me start with what I think are the easiest questions. It's not clear, and I just want to get your input, is there a multiplier effect? In other words, if a household has 2 people with licenses or 3 people, can that household have 12 plants or 18 plants as opposed to just the 6?
So Chip Paul, Oklahomans for Health, yes, they can. So again, and I know if you're not kind of familiar with the industry and, you know, kind of how this works as a medicine, that seems or could seem somewhat threatening. But again, you have people that are really, you know, the intent here is to have people literally growing their own medicine. And we've kind of established, you know, is 6 the right number of plants? Well, we thought so and kind of put it in the law that way. But you should have the right to grow 6 plants if you're a patient. I should. And if we live under the same roof, then, you know, well, that's 12. So, yeah.
All right, so
I would like to add to that. I'm sorry, Smo, Green the Vote. Keep in mind that they've got to have the room to grow that. So just because there's 3 card holders in the house and they can now grow 36 doesn't mean they suddenly have a wing on their house they can turn into a grow, or everybody has a yard big enough for whatever it is that you might be worried about numbers wise. So please keep that in mind. Just because everybody in the house has the right to grow it doesn't mean they're going to grow the full maximum amount.
One of the things that I was curious about that 788 did not address, and that is in the current law at Title 68, Section 450.2, there is already in place a tax of $3.50 per gram on marijuana. That is not at all addressed. Are you assuming that we're going to repeal that?
Chris Moe, Green the Vote. I worked on 3468 with Representative Jordan earlier this year, and I can tell you that was our full intention to get rid of that. I've actually purchased some of those stamps. Someday those will be collector's items. But yeah, we did address that. Not here, of course, but we've talked about that. That needs to be eliminated.
Ron Durbin, Green the Vote. If I could add, that is one reference to one statute where there is a problem with 788 and existing statutory statutes that are in effect right now. The Department of Health in one of their new regulations adopts part of the food code, which is 63 OS 1-1101 et sec, I believe, is the reference. And in 1102L, one of the standards says you can't label any product with a controlled dangerous substance name. Well, if you label the products correctly under the statutory scheme and label it cannabis, you've now made it illegal because this law conflicts. There are lots of areas that this legislature needs to address as it works through how to properly implement this. We have to commend Chip and all the people who advocated for, getting 788 passed, but there is a lot of work that still needs to go into this. That's one example. Other criminal statutes dealing with, cannabis being in a food product or adulterated food products. There's lots of areas that need to be addressed in this. Rachel Bussett, which the committee may or may not know, and I were ones that were meeting with the Department of Health this morning. We brought up some of these issues. I think a lot of this, though, has to be you guys because there's statutes that conflict with what we're doing. So there's areas that we can leave to a regulatory agency, but the areas where there's this conflict of ideas between 788 and existing law has to be addressed by the legislature and needs to be done in a comprehensive way.
Rachel Bussett for Oklahomans for Health. I also represent the individuals in the lawsuit down in Cleveland County. I've listened to all of the questions this morning, and I think one of the most important things for all of us to remember is that 788 only created 8 new statutes. In Title 63, we have 85 titles and I don't know how many statutes under Oklahoma law in addition to the administrative code and the Oklahoma Constitution. And the passage of 788 and the creation of those 8 statutes didn't make all of that other law poof and go away. It still applies, guys. It's still there. 788 works in conjunction with probably 95% of it. It supersedes maybe 1 or 2% of it, and it's in conflict probably with 2% of it. And that's where y'all have to come in and do some work. There is work that needs to be done. This branch is the legislative branch. Y'all are charged with enacting the law. That's your role. The administrative agencies, they're part of the executive branch. Their role is to enforce the law. In order to enforce the law, y'all have to delegate authority to them through enabling language. 788 has very limited enabling language in it to the Department of Health. At the end of the day, while the Department of Health is what was chosen in 788 to implement this program, it's really not the appropriate agency because 788 goes across multiple disciplines: medical, pharmacy, agricultural. What really needs to happen in having a legislative fix, because there are holes and there does need to be some legislative fix, at a minimum there has to be this legislator giving the appropriate enabling language for an administrative agency to make the appropriate rules. But y'all need to create a title that relates to medical marijuana, especially if 796 and 797 get on the ballot and pass. It looks very likely that they're going to get on the ballot. We already know that there's enough signatures for 797, and if that is slow paid and doesn't end up on the ballot, like it's been reported in the news, you're going to have a big backlash on that. I don't know where they stand on 796, but the last I heard, they were pretty close on the signatures. I anticipate they're going to have all the signatures that are needed to have 796 on the ballot in November along with 797. I encourage everybody in our government to work to put this to a vote of the people so that when you all come back into session next year, we can get everything done that the people of our state want with regard to medical marijuana, recreational marijuana, whatever it is that the will of the people want, and that y'all come in and you do it right once, and you do it right the first time. You create an agency that is for marijuana in the state. You create a title that is for marijuana in the state. That you do what the people intend, that you look at this as a medical bill, that it is not for you to prescribe what the people are allowed to take, that it is for the doctors to prescribe. While it might seem like a lot to all of you or even to me for 3 ounces or 72 ounces of product to be in one person's possession, you do not know as a non-user how that affects them, what their tolerance is. I was on pain control for many, many years and was dispensed 60, 90, and 120 tablets of opiates for a 30-day supply. I submit to you that is a lot of opioid medication to be given to someone. I submit to you it's a lot to ask for 2 physicians to sign off on medical marijuana for someone under the age of 18 when nobody had to second guess my daughter's primary care physician when she was prescribed opioid medication because she broke a bone. I submit to you it's not for you, unless you've been to medical school, to second guess what a doctor says in the privacy of the room. The people intended for all of this to go through. I appreciate that you all have come here. I appreciate that all of these groups are working together. We need legislation. We need the gaps to be filled. But the people intended for this to happen as it has gone through, we need to all work together to fix it. The people intended to fund education and drug and alcohol rehabilitation, and I'm asking the legislature to rebuild the trust that we talked about earlier, lacking in all of us to come together to fix these rules and to build the trust that Mr. Durbin and I talked about with the commissioner over at the Department of Health this morning.
We're going to have to keep our answers shorter. So we're never going to, guys, I work notoriously long hours. I am here till early in the morning, late at night. It is nothing for me to stay here as long as you guys want to stay here. I just want to be clear. Come hang out during session, and I can't complain to my speaker because he is the only one that works longer than me. But we have got to keep it a little bit shorter, or we're never going to get through all this. But
and Representative Eccles, just real quick.
Again, keep it short, and then I got to let Representative Loring ask another question.
Absolutely. Just on the tax stamp, let me just say this. If you didn't repeal that, that leads to about $126 an ounce. Shockingly, that's probably about in the range that the market will land anyway. So I mean, we would appreciate it if you did repeal that, but if you didn't, you kind of fixed a price in the market. So
I'm going to give you some more time, Representative. Keep going.
Thank you. So what you said led into another question. Again, 788 is not clear on this, but I'm assuming that we're all talking about when the patient meets with the doctor, it is an actual face-to-face consultation as opposed to, for instance, a doctor that just signs off on these cards over the internet.
Ron Durbin, Green the Vote. We would agree with you that it should be a physical interaction between a patient and their doctor. While telemedicine is a wonderful, fantastic thing in a lot of regards, you know, it's not something that should be advocated, at least in our opinion here. That doctor-patient relationship is important. I think one of the concerns that's premised in your question is teleconferencing with out-of-state doctors that get a license in the state of Oklahoma for purposes of writing a recommendation here. You know, certainly restrictions can be put into place to kind of allay those fears and make sure that it's a doctor-patient relationship. I think 788 already does that and requires a doctor-patient relationship.
So Chip Paul, Clemens for Health. In going through this with the Department of Health, I mean, there's intent here really with this doctor-patient relationship. I mean, and it's very specific. We want that doctor-patient relationship, absolutely. We want that to be well-defined. But we also, and absolutely telemedicine was envisioned in this, no question. I mean, I know what I'm thinking, and telemedicine absolutely was envisioned under 788. But again, that telemedicine can't be like it is in California. In California, you dial up a guy and you tell him your condition and he agrees with you, medical marijuana will fix that, and he signs your thing. Not here. We don't want that here. So telemedicine, but with a defined doctor-patient relationship in a similar way that it is if I was sitting in front of you in your office. It has to be well-defined, and that's very important. That's a very important intent under the law. We want that well-defined.
So the chair is very kindly giving me one more question. Let me go to one that I probably have the most concern about, and that is liability issues. I mean, I can foresee lots of lawsuits coming against doctors, against dispensaries, kind of a dram shop type theory type thing. If for instance, a dispensary were to sell to somebody that they legally should not have sold to for whatever reason. But I can see lots of potential lawsuits coming out of this. I'm concerned about, for instance, doctors with medical malpractice. Would they be covered by that, by their malpractice insurance? Can insurance protect those individuals, and in other words, protect society as a whole, when we're dealing with a product that is, at least at present, federally illegal?
And Representative Bud Scott, New Health Solutions, Oklahoma, thank you for that question. And if you look actually in our section related to physicians, we specify about non-liability for physicians for either administering or recommending this product. So a waiver from both civil and criminal liability on this matter. And I think this is the way this should be approached. There's going to be litigation in this regardless. I think we're going to see a lot of this flesh out, just like we do every industry.
Chip Paul, Clemens for Health. We really don't see a lot of lawsuits and things like that around this industry in other states. And again, that's public record. You can look that up. But certainly things get challenged, right? So when we look at the doctor-patient relationship, we want that to be tight. I mean, honestly, we want the doctor on the hook. He needs to have legal, ethical, moral responsibility in that decision. So if he needs to insure his way out of that, fine. But we want him to have skin in the game. That's important.
Ron Durbin, Green the Vote. This area, I was waiting for this area to come up because it is a concern, I think, for everybody. It's a concern for doctors. It's a concern for dispensaries. It's a concern for everybody. One of your questions was, is the dispensary going to be held liable for dispensing this? Well, they're doing what's allowed by law. So that would kind of kick out negligence per se from what they're engaging in. But I think you would apply a general negligence standard there. And that same as if a pharmacy improperly prescribes or dispenses medication to somebody or gives them the wrong medication from what they were supposed to get, they're still going to have potential liability there. Are there areas that the legislature can tighten up? Absolutely. There's areas with regards to operating motor vehicles where it could be a potential problem, and there could be a negligence per se type issue there. All of those things do need to be addressed by this legislature, providing the doctors some protections. Providing them blanket protection, as might be proposed by New Health Solutions, probably not. Because if a doctor is acting outside of acceptable standards, they should be still held responsible for their actions and for their negligence. There is a compromise and a window here with which to work 788 and medical cannabis into all of the intricacies. And I practice primarily civil litigation doing these kind of lawsuits that you're worried about. And I think there's a way to accomplish it while not creating a special law which the legislature has a tendency to do, and while not going too far, which the legislature has a tendency to do. It needs to be narrowly construed, narrowly drafted, but to provide some protections for those areas that you're concerned about.
Thank you for that. Leader Copeland, you are recognized.
Thank you, Mr. Chairman. Thank you all for being here and bringing a lot of information to us. And I have so many questions, and I don't know where to start, but I'm going to follow up kind of on Representative Loring's question. The doctor, and I heard someone mention earlier that, I mean, how familiar is the medical community with really prescribing the amount of medical marijuana a patient needs? And is a nurse practitioner in rural Oklahoma, we have a lot of nurse practitioners that take care of our people, not doctors. Will they be able to sign off on these?
So Chip Paulo, Clements for Health. No on the physician's assistant. You know, you have to be a board certified, and we'll probably argue over that forever what that means, but board certified physician here in Oklahoma. What was the first part of your question again? I had an answer for you.
Well, the knowledge that the medical...
Oh, yep, very good. So perfect. And again, this is part of why this was written this way. And it, you know, what I do every day, what I do for a living, again, I have an herbal supplement company, but I research the endocannabinoid system. And I know to a lot of you that sounds like I'm a snake oil salesman or something, but I'm very serious about what we do. And I read research papers on this medical system all the time. This is what medical cannabis affects, the endocannabinoid system, okay? And it's it turns out it's literally your master regulatory system. It runs every single function in your body, and it's manipulatable by medical cannabis. It seriously is like a master screwdriver into your body, into how your body functions. But no physicians know that yet. So this is just beginning to be taught at major schools, medical schools and universities. I'm actually humbly privileged enough to be able to be inputting into one of the first classes at a major university where this should be taught every day, a PharmD PhD level class. So I apologize to kind of go around the corner here, but to your point, no, physicians don't know about this system yet. That's why what we're doing here in Oklahoma is so important nationally, because how do you drive pressure on a physician? How do you drive change into a physician community? They're not changing around the medical marijuana condition. They haven't, right? You don't see physicians with a lot of knowledge about this system yet. This is why this is very important, what we did here in Oklahoma, because we'll shame them, frankly, here in Oklahoma into learning about this system. How many times will your family doctor hear someone come in and say, Doc, how come I can't get how come you won't prescribe me medical marijuana for this condition? It won't take long before he starts reading and researching and understanding about this incredible system that can literally treat, and again, I apologize to diverge, and I'll take about 2 more minutes here. But if you think about this, consider let's just go to the pain spectrum, okay? The pharma pain spectrum, okay? And you think, if you come to me and you say, I have pain. So on one end, I can prescribe you ibuprofen, NSAIDs, right? We all know what those are, anti-inflammatory drugs. Those have contraindications. They are not safe, Hurt your liver, stomach, all that. Go to the other end, you got opiates. Those kill you, right? So when you go talk to your doctor about pain, there's nothing in his pharma FDA, pharmacopoeia that he can prescribe to you that's safe. We're giving him a completely safe option, okay? So he needs to understand what that means, how powerful that is, how it should be prescribed, under what conditions it should be prescribed, under what conditions it shouldn't. But the only way that we're going to drive that is by leading that. And we have an opportunity to do that here in Oklahoma. We've given you a piece of legislation, a piece of law to lead here. So your question is incredibly important. We're going to educate them. We're going to shame them into learning. But we'll have avenues and opportunities for physician education, absolutely. And that'll be done through the, potentially through the trade organization. I know there's a well-known expert in the field, a lady named Dr. Regina Nelson, who's interested in setting up, CEU-type classes for physicians and things like that. And I apologize for the long answer, but you asked a very important question.
Ron Durbin, Green the Vote. There's no national standard set on dispensing amounts or doses for medical cannabis at this point, if that's what your question was, and I think that's exactly what your question was. It's a situation where doctors who are going to recommend this are going to have to work with their individual patients and determine proper dosing levels and those things in conjunction with their relationship and ongoing relationship with their patient. But there are no national dispensing and dosing standards at this time.
Leader Copeland, Bud Scott, New Health Solutions, Oklahoma. To answer your question about the PAs or the assistants in the scope of practice issue, in a lot of our feedback that we received on our proposed legislation, we addressed a lot of these issues because in 788 it specifies, it says an Oklahoma board certified physician, which there's several definitions for what physician actually means. We settled upon a section from Title 52, which describes a very specific set of physicians. It's where it's defined in statute, but ultimately this will be up to the legislature to make that determination on that scope of practice portion. I think there's a lot of concerns about accessibility, as you're well aware of in rural communities. There may not be an abundance of MDs or DOs to make these recommendations, and so we should have a little flexibility in which professionals are medically trained and capable of making those recommendations for each patient. Now, I will say, if I can have just one more second, Representative, that under the guidelines of 788, this is just one more reason why we need to specify this and clean it up in legislation. The health department has attempted to claim that only MDs and DOs can participate in this program, and that is well beyond their statutory authority.
Any other comments from anybody? I've got some other questions, but my time's probably getting short here.
You got about 3 minutes if you want them.
So I better go to the original question. 788 had some timelines in it. What do you think is a realistic timeline for us to get proposed fixes done to implement 788? And when I say done, do you believe that the Department of Health can implement 788 without the legislature adopting statutory rules?
So Chip Paula, Clements for Health, I do. I think that they can. Again, right now they're being driven every which way from Sunday, right? Where we got to on Thursday was a really good place. It's I think we conceded points and they conceded points, but we got to a really good place Thursday afternoon. We spent 3 hours, with Interim Commissioner Bates and his staff. That's not really what you see that's out there today. And again, they're being driven all over the place. But that's what they do. They regulate, and they frankly, I've read these regulations for 4 years. I've lived in this stuff for 4 years. I've talked to state regulators. I've been all around this country with this issue. Our Department of Health, for not knowing anything and just getting started, and spun up, they've done a fantastic job. So, I think if we roll back to where we were Thursday, again, if they adopt what they did Tuesday, today, that's workable. If we roll all the way back to where we were Thursday, that's a really workable program. Does it need to be adjusted? Yeah, absolutely. It'll need to be tweaked and fixed and all that. But again, we won't really know where the warts are until we run it a little bit. I think we know that we need probably, a regulatory commission. I think we'd all, agree to that. But definitely the Department of Health could, if everybody kind of leave them alone, produce something I think that's workable and that we would agree to as proper under our law. So.
Ron Durbin, Green the Vote. With regards to leaving the Department of Health alone, they've shown that we can't do that. Their current regulations make it legal and then make it illegal at the same time. So leaving them alone, I don't think is the right course of action with regards to that. But as far as a realistic time frame, you've got New Health Solutions that have offered a now 70-page shorter version of statutory schemes that could be implemented. We, with Green the Vote, have offered statutory schemes that I think total about 34 pages. There's framework in both of those. Certainly we don't agree on everything. There's no doubt about New Health Solutions and Green the Vote agreeing on everything. We think they go too far. They think we don't go far enough in some areas. But I think if you sat down with both of those schemes and frameworks and 788 as the guiding principle of that, you can come up with a regulatory or a statutory scheme and statutory framework to properly give an agency the ability to regulate this industry and do so in an expeditious fashion. I think that if you work towards that goal, which I believe this committee is doing, you can get there quicker. Can you stop the train that is 788? At this point, no. There's not going to be a call for a special session that I'm aware of from the governor, so you're not going to be able to do that. So you've got to work with inside of what's already going to be in place. But I can tell you right now, we're here back again this week. We'd probably be back here tomorrow if you guys asked for us to be here tomorrow to try to work through point by point, statute by statute, what issues there are and try to come up with something right now. I'd be here. I can guarantee you Bud Scott would be here, and I know Chip Paul would be here. Isaac and Chris would also be here. We're here if you need us, and I think that's what needs to happen if you want to get something in place quickly.
And Representative Bud Scott, New Health Solutions, I think we fundamentally disagree that the health department can implement this in a responsible and timely manner. I think they're doing their best to do this, but the timelines that they've been forced upon, or that have been forced upon them, you're asking an agency to start issuing licenses for this industry basically August 25th. They have to start accepting applications. There's a 2-week turnaround period by virtue of State Question 788. That means you're asking an agency to issue licenses for companies that will be making a controlled substance, and they haven't even had site inspections. They haven't even had plumbing inspections. They haven't had fire code inspections, something that every single business in the medical industry actually is required to go through. So it's clearly been our contention that if we do not address this during that 2-week window, basically from August 25th until that 2 weeks is up, with them having to issue licenses to potential business applicants, we're opening a gigantic can of worms. And this is just fundamentally bad public policy. We really need to address this to set forth how these programs will actually operate. And we believe we're trying to provide as many recommendations as possible for your legislative body to consider. But yeah, we fundamentally believe that we've been calling for it the whole time, special session.
Yeah, and again, Chip Paul, Oklahomans for Health, that we don't think we need a special session. And again, we do think that the Department of Health is absolutely capable of implementing this. And again, the times are there for a reason. I'm an entrepreneur. I'm optimistic. I think we can do things. I think we can do things fast. Why not? The Department of Health we have patient licenses up. They've sort of completed task 1. They've selected an IT vendor, to do all this. So they're moving fast. They're doing a great job at the staff level of doing everything that's required here. So is this going to need to be fixed? Is this going to need to be probably changed and tweaked and massaged? Yeah, but again, we put it at the Department of Health. They're responding. They're doing what they need to do. I can't believe I'm sitting here defending the Department of Health after everything that's happened. But, if we can get past the board level there, and again, we'll see if we can do that. But the staff there has been, they're regulators. This is what they do, right? They live in these regulations every day. They understand this. They understand how to tighten things up, so.
Chris Moe, Green the Vote. I'd just like to say, I understand what you're saying. There's a lot here to work out in a short amount of time. Here's where I stand. Special session, not special session, don't really care. Patients need to get their cards as fast as possible. If you can figure out some way to roll out part of this so the patients can get their card and start growing their own medicine and stop worrying about getting arrested, I'll support you. If the whole program gets slowed down because you're trying to work out some of the business problems, there's going to be some backlash. And I mean that with all due respect, but we have patients that need their cards as soon as possible.
Thank you for those questions. Senator Yak, you are recognized.
Thank you, Mr. Chairman. One of the advantages of going late in this process is a lot of my boxes have been checked, but I would like to follow up on a few things. I appreciate the other committee's questions. They're very thorough and well thought out. I appreciate the responses that we've gotten so far. I think one of the challenges that we've maybe defined today is that this is a cumbersome process. How do we get there? And maybe we just talked about the timeline. Maybe the timeline, we want to do it right, but what my definition of right, her definition of right, your definition of right, how do we get there? Most of what comes out of this building is a result of compromise, and that's an arduous process, and it's there for a reason. I think, Mr. Scott, you mentioned last week, maybe again today, but you mentioned last week, there's a reason you put those aggressive timelines in there, because you want it to happen, and I get that. So how do we get there? That's my question, and I appreciate this process. We've got other groups to hear from. I appreciate your willingness to be here, but there are other groups that this committee needs to hear from going forward, because this is going to have to be a work in progress as we go forward. You're welcome to comment on any of that if you'd like, but one of the questions that I have, we've talked about federal law a lot. Like it or not, this is still an illegal substance as far as the federal government's concerned. So how do we look past that? Banks are bound by that, and they're playing by those rules. So are you concerned that if, I think Mr. Durbin, you said some of those laws are being relaxed? Maybe they are, but maybe they aren't. But if that doesn't happen, what if they go the other way? What if they decide to crack down on the states that have passed medical marijuana or marijuana in some form? How will that affect this your business, and how will it affect that affect the state in general? And you can comment on that, and maybe some of the others as well.
Sure. Ron Durbin, Green the Vote. Unfortunately, the Commerce Clause of the Constitution authorizes the federal government to regulate things that are in the stream of commerce. They have wide-ranging authority to usurp the power given to the states under the 10th Amendment. We all know that, and we understand that. The federal government could go either way. As the tides change, things could change. If they went more stringent, that's certainly going to impact every single state that has a medical or recreational cannabis program. I think that the tides have turned and the poll numbers have turned to such a degree that that is highly unlikely for them to do that. It's just too widely accepted in too many states. 30 states have either a medical or recreational program of some kind or another. So I don't see the federal government going more stringent. As far as the banking issues are concerned, the state can authorize and allow banking institutions to be instituted that apply and only operate inside the state, and therefore they don't have to have the FDIC or the credit union insurance from the federal government. The state could take action there to try to carve out some kind of banking system related to this industry. One of the things that the regulations should do, or the statutes should do, is it should create tight financial reporting requirements for these businesses to report, so the state can track money, track taxes that are supposed to be paid, those kind of things. But opening an avenue for businesses to be able to bank in a realistic, non-cash manner is something that we should strive for. No other state has really come up with a great solution for that. We're given an opportunity to try to come up with something, and a state-regulated banking industry specific to this market would be one way to go, and we would encourage you to look into that.
Chip Paula, Clements for Health. If you look federally, you can kind of, I would say in our community, we were uber scared of the Trump administration, and mainly because of Jeff Sessions, right? So I don't think it can get any worse, and I'm a MAGA guy. I voted for Trump, so I'm a Sessions supporter. But as far as our community goes, I don't think it could get any worse than a Jeff Sessions as Attorney General, okay? And you look at what he did, and he repealed something called the Cole Amendment, and that caused great furor in the cannabis community. But you've seen how that community has responded. And again, that community has responded federally with legislation. You've got, all the Colorado lawmakers just up in arms about that. And so you've got a lot of pushback federally. And I think that's been recognized by the Trump administration. certainly by their support of this Senate bill that again, it's initiated by Cory Booker and Elizabeth Warren. You've got two, people on the extreme left, and then you've got, President Trump on the kind of the extreme right also supporting this. So I think you're going to see federal action probably in the next 2 years here. But just consider this, 30 states have medical marijuana programs. I mean, we certainly have the power to call a constitutional convention and have our way. Right? That's certainly possible. And I think that that's kind of the federal threshold. I think our state, if we somehow get recreational, adult use marijuana on the ballot, and again, I know that probably scares the heck out of everybody worse than, our medical, but we're the tipping point. We'll be the tipping point federally if that happens, I believe. So, but there's a lot of attention and focus on this now. And to Mr. Durbin's point, we do need banking solutions. And again, that is something that will somewhat fall to you guys or the tribes, frankly, to help us with as an industry.
Senator Yeck, Bud Scott, New Health Solutions, Oklahoma. The legislation that's being referred to is the States' Rights Act in D.C., and it's Senator Cory Gardner, who's a Republican from Colorado. That's the co-sponsor with Senator Elizabeth Warren out of Massachusetts. Unfortunately, what we're looking at this point is that we have legislation in D.C. that we can't depend upon the movement in Congress to base our industry around. So there is a need for us to come up with some local solutions to this. I don't think that it's prudent that we'd be able to address this at this moment, but perhaps, and that's something we've been speaking with the Banking Commission on, and several different banking entities here in Oklahoma as trying to reach towards a regulatory and statutory solution for this, that there's other examples in other jurisdictions, notably Oregon and Colorado, for their credit union language that we could pursue here potentially in 2019.
Thank you. Mr. Paul, I want to go back to the amounts of possession that are spelled out, and you talked about that a little bit, that was greatly debated. I think you said how you arrived at those amounts. So those amounts that you came up with that are very specific in 788, how do those compare to other states that have medical marijuana?
They are not the highest by any means, but they're higher than most states. And again, the intent there, our community is very concerned about law enforcement breaking in the front door and where is that line? Okay, so where is the legal line? Some people in our community literally break, they're great citizens, they break one law. They're just like you, but, if you broke one law, but you felt valid in doing that, you would be very concerned about how that law gets enacted and put in place. But certainly when it comes to, your house, your personal freedoms, okay? So we wrote that with the intent to provide a maximum where we wouldn't have our doors broken down, frankly, and that's really where that came from.
So, Mr. Scott, Mr. Cavanis, did your in what you've presented so far?
Yes, Senator. We had the same limits because that's what was approved by the vote of the people in 788.
Yeah, Isaac Havness. Again, everything that we've tried to put into place in any of our ideas have been a direct result of the language of 788.
Thank you. On the taxation issue, kind of the same question. So 788 calls for a 7% at the retail. Same with both of the other drafts? It's the same?
Yes, and for the same reason, and there's an argument to be made. I think it started to be made earlier that most medications aren't taxed. We would love to see that tax go away, but we have to be realistic about the fact that there's going to be a need for an amount of money to make this regulatory system be able to function.
And Senator Bud Scott, New Health Solutions, I would echo that exact sentiment. We kept the 7% in our proposal, primarily because the restrictions on State Question 640, we don't believe that we could actually include in a legislative package unless we had a supermajority vote to support an additional tax increase on this.
And you're in agreement that the state and local taxes are in addition to that 7%, I assume?
So clarify what you mean. I'm sorry, Chip Paul, Comes for Health. Clarify. Like a sales tax?
Well, just the sales tax that would apply to any other product, state sales tax.
No sales tax on this product.
There's no sales tax on
No,
this.
sir.
Ron Durbin Green the vote. I don't think that's the way that the Oklahoma Tax Commission is interpreting it. They're interpreting the 7% and 788, rightly or wrongly, as an excise tax, which would be a tax in addition to normal sales and local taxes. So it'd be, I think Bud actually mentioned the number earlier, 15.5% is what it should roughly come out to. Again, rightly or wrongly, that's how they're interpreting that 7%.
And Chip Paul, Clemens for Health, that's a 7% tax. There's no, and I know it says sales, but again, the intent there was a 7% tax on marijuana sales, no additional sales tax. That was the intent. So again, right or wrong, do municipalities need a piece of this or whatever? The 7% was there as the only tax, and that 7% was to go to the Oklahoma State Department of Health.
So that's the intent of 788, is that would be, there would not be sales tax, state or local, in addition to that.
It's a medicine.
But the tax commission's not interpreting it that way.
I know.
So if it's open to their interpretation, then that leads me to believe that there will be some challenges whichever way they go with that, which could lead to a 640 question.
That's a debatable, should there be a sales tax on this or not? That's a hot debate. I would argue no, and I would argue no, that our intent, was not to have a sales tax. I completely understand the reason for a sales tax and the need for a sales tax. So is that we have to poll the community, honestly, is that a live or die issue, for our community? And I'd want to know what they think, really, but it's open to interpretation right now.
In you all's knowledge, has the AG weighed in on that question to this point?
Not yet.
Senator Yeck, the Attorney General's office has not weighed in specifically on that issue. The Tax Commission has. They've been very clear that they're treating this as a excise tax in addition to the sales tax. Now, if that's something that needs to be clarified, it's just add that to the long list of things that we can address through statute.
I'll ask one more question on how I'm doing on time, but one of the points we talked about a little bit is the validation system, the PMP program. So, Mr. Cavanis, I think your bill addresses that in the very beginning in the application process. I think it addresses that. So,
Ron Durbin, Green the vote. There absolutely has to be a validation system of medical licenses. I mean, we have, as an owner of several bars, we have situations where people present fake IDs, but for us scanning those codes on the back of a driver's license, we would be letting people into the bars that are under the age of 21. We don't want that to happen. This industry can't let that happen. So there absolutely has to be a validation system in place to validate the legitimacy of a medical cannabis card. One of the concerns that I had from the meeting this morning is that the way that they're regulating it now is going to be, there will be a voluntary phone-in system to check on the validity of it, but it is not going to be mandated or required. I think that's a problem. The problem stems from the fact that they don't have the authority to regulate that area by enacting language to give them that regulatory authority to put that in place. But that is absolutely, along with all the other things that we've talked about, things that need to be in place, laboratory testing, all of those other things. There has to be a validation system, or this system is going to be what it is all the proponents were against, which is a system that's kind of the wild, wild west. And we're not advocating that. We want a system that works.
And Senator Bud Scott, New Health Solutions, just to add upon Mr. Durbin's comments here, what you typically see in another program for regulating medical marijuana is you see a patient registry database. You also see inventory tracking systems, and those are all proposed within our legislation and pretty well fleshed out as well, with models that we've seen be successful in other states.
one more question, Mr. Chairman. I think this is just a definition. So under this is section 1, Mr. Scott. So if you could tell me what is concentrated marijuana and what is edible marijuana? Whoever wants to respond to that, I don't care.
Since you asked specifically, there's various kinds of processed marijuana products, and as this industry has evolved and as people's really entrepreneurial spirit has evolved, there's a whole range, everything from edibles, that means it's generally a product infused with the oil that is extracted from a cannabis plant. So you can refer to them as edible infused products. There's also straight extract, where it's the oil that is pulled from the plant through a variety of processes, whether it's a water-based process, whether it's a heat-based process. There's multiple ways of doing this, and you can pull that out and turn it into a concentrate, which is either an oil or something like shatter or wax or ash. So these are all of the varieties of processed items.
Mr. Paul, I apologize. That might have been, you wrote the bill, and that's your terminology, so maybe you're better to weigh in on that.
Yeah, so no, Mr. Scott did a great job of it, but Chip Paul, Oklahomans for Health, he did a great job of describing those different things. But it, you'll notice, and again, nobody knows about this industry, yet, and I think that's why it's so valuable for you guys to take a trip. I mean, let's go look and see how this really works somewhere. But the reason that we have this interim license called a process license, yeah, you two will be front and center, right? But the reason that we have this whole thing called a process license is for the very reasons that you're talking about. So processors will take, whole plant, raw marijuana, and will basically, through a variety of things, heat or cold or different processes, turn that into oils or turn that into edible products or both, or powders or all different kinds of things. But in a real kind of, pharmacy laboratory way, they'll be doing these things, extracting and doing things like that. So that's the whole reason why we need this process license, is this sort of mid-tier license, and that's how we regulate that whole endeavor.
Thank you, Mr. Paul. And when you said I should take a trip, I think I knew what you were referring to.
Yeah.
It's hard to resist.
Industry trip.
Those happen innocently, don't they? Thank you, Mr. Chairman.
It's unlike 788. It's always good to specify, right? So.
Oh, in two committee meetings, that was our first pun. I'm very impressed with us. With that, I would like to thank you for that, Senator. I would like to recognize Senator Daniels. After Senator Daniels, I'm going to recognize Representative Dolan's for one question. I'm going to ask mine, and then we will allow additional questions from the committee.
Thank you, Mr. Chairman. Getting to go almost last. Many of my specific questions have been addressed, and I have others, but the conversation has gone in a direction that I want to go a little bit more, have you be a little bit more specific with us on the whole picture after the gentleman said that the most important thing is to get the licenses so that patients can grow their own at home, that that's the most critical piece of 788 in your view. Just to let you know, though, what I think my role is and why I wanted to serve on this committee is that ultimately 149 elected representatives and senators of all the people of Oklahoma will be required to implement this final legislation. I don't see anybody in this room as an antagonist. You voted for it, you voted against it. I represent all your views. I do not see law enforcement as an antagonist. I do not see the medical profession, the business community, education institutions. These 2 weeks, I've already learned a lot about a product, a process that I knew nothing about. And I'm going to build on that knowledge. But I also do have to address the concerns of those we have not yet heard from, because this is going to cost taxpayers. Even if ultimately it generates revenue, to set it up is going to require a budget in competition with all the other budgets that we must consider in Oklahoma. So 57% of the people have voted to have maybe a new agency, maybe a whole new set of spending. So I understand that we must work quickly. I would prefer to say expeditiously, because I want my colleagues to know that when I recommend legislation to them that's voted on, they can be assured that we've done our very best to answer all the questions and solve as many problems as we can, because we also know litigation costs taxpayers as well. So, having given my little speech, here's what I'd like to know from each of you. What are the 2 or 3 most important things about 788 that we should focus on now? And I'm using your comment about licenses for the people to grow it at home. That would be one. So to help me direct where I really need to focus, what are the 2 or 3 most important things you think we should be addressing?
Chris Moe, Green the Vote. I'll start this off. I'll just build on what I said. Patients getting their licenses is something you guys need to do as soon as possible. Another thing would be addressing some of the law enforcement issues, because until the patients have their cards, we have law enforcement that are still, as they say it, upholding the current laws. So from my standpoint, it's the cards, it's the legal system or the laws that are getting people arrested, and with the cards comes the home grow. You guys can work out the business stuff, we can start growing. We'll be on track to have our own medicine about the same time the dispensaries do, and if we have to wait for the business end to get lined out, we'll be 6 months behind them. I mean, we'll spend the next year trying to catch up, and we'll go without our medicine. And again, that's my main concern, is that everybody get their medicine as soon as possible. So thank you.
And I just, Chip Paul, Clemens for Health. Absolutely what Chris said. Patient access is number one. But that's a little bit bigger question than just providing, patient licenses, right? That means there's access in some kind of a business situation where those patients, can access medical marijuana. So those two things are the most important things. Clearly, we wrote the law. We expect the law to be honored. I mean, 57% of us, said yes. So we expect, some absolutely, firm guidelines around honoring the words unless there's additional clarity or, definition needed under those words, because that's what we just approved as a state, as voters.
Bud Scott, New Health Solutions, Oklahoma, to respond to your question about 2 to 3 most important points. Beyond what's already been mentioned, I think it's highly critical that the non-qualifying condition component of State Question 788 is honored. That is a very unique keystone to this program. It's very unique for the other medical programs across the country because it's evolved beyond just the step where you have, say, 5 listed conditions and a very cumbersome process for adding to that condition list. So it allows for a maximum amount of patients to seek relief under this program, and then also creates an incredible market opportunity for the state as well. So I think that issue right there is just absolutely essential that we're able to keep that in play. The other portions of this are obviously figuring out our business licensing.
Any further
I
questions?
yield.
Thank you, Senator. Out of deference to a member who is not in the committee but has been here with us all morning, I'd like to give Representative Dolans, he has texted me he'd like to ask a question, and I'd like to give him that opportunity. Representative Dolans, you are recognized.
Thank you, Mr. Chairman. I appreciate the leniency. I'm here today on behalf of my constituents in District 93 who are concerned about ambitious entrepreneurs from out of state who are wanting to take advantage of this budding industry. I wanted to get your opinions on the residency rule. Do you think it's too strict, and what would you change about if you could?
So Chip Paul, Clemens for Health. We were pretty specific in those rules. Again, we've seen and paid attention to how this has been done in other states, and we wanted to create a situation here in Oklahoma where we did provide an avenue for outside interest, outside investment, and outside expertise. And I think you'll see that we did that by allowing up to 25% investment, in a marijuana commercial entity. How we protect against, though, really big players coming in is by the very things that we did in the mechanisms in the law. We don't limit licenses. When we begin to limit licenses, then you just ramp up this dollar tier of what it costs to play, of what it costs to be able to get one. And again, who has money in this space? Who's interested in coming in here? Well, absolutely, there are big California growers. There are big Colorado growers. There are people who put a lot of money into yes campaigns that are interested in coming here. So we need to be concerned with that, absolutely. We need to give, this is about us. It's a we the people thing. It's an opportunity for we the people to be entrepreneurs and participate in this business. So we need to guard consumer safety, as we sort of establish those rules, but we absolutely do not need to restrict any Oklahomans really, right or ability to enter this business.
So Representative Dolan's, Bud Scott, New Health Solutions, Oklahoma. I'll try to respond to your question about how effectively keeping out-of-state interest from here. The residency requirements spelled out in 788 are tepid at best. We've proposed we actually have a 2-year residency requirement in our legislative proposal. Now, this is a point of contention legally across the industry because states are starting to get rid of their residency requirements because this has not been fully litigated out yet. But we're proposing that we have actually stronger residency restrictions. And again, once again, the reason for us to have to address this through legislation in a special session most likely is because ownership interests are not defined and there's inconsistent terminology in State Question 788 as it applies to those ownerships and whether they're allowed to have out-of-state investment or full-blown Oklahoma residents. We provide extensive language on how that proposal would actually operate. I think this is something we clearly need to address because there's been ways of doing this. I've done this on behalf of clients in other states. There's ways of circumventing residency laws and restrictions, and there's laws that have developed to address those issues. That's what our proposal has, are those addressing laws.
Ron Durbin, Green the Vote. Some outside investment from states that already have a medical program or a recreational program is sort of essential to this market. As we've talked about with banking restrictions and funding restrictions, having people who are already knowledgeable about this industry coming in willing to loan money into the industry and loan their knowledge into the budding industry in the state of Oklahoma are key and essential points of 788. That's why I think there was a restriction to 25% and not a complete and total restriction, because we want to allow that. What I think where the issue arises, and Bud kind of talked on this briefly, the way the residency restrictions are set up right now, it's restricted on who owns the company that holds the processing license or the growing license or the dispensary license. If you gave me about 10 minutes, I can set you up a company that can own 100% of their interests and siphon off every bit of the money off of a company that holds a processing license, and it go to a company that's completely held by outside interests from any other state or foreign government or whatever. It's not hard to do the way it's currently structured. There needs to be to tighten it up and achieve the goal of 788, there needs to be some strengthening. But make no mistake, it would not take an intelligent attorney or business person 5 minutes to figure out how to get around this requirement and siphon off every dollar out of this state. It's not that complicated.
Thank you for that question, Representative. My friend from South Oklahoma City. I am going to ask some questions as the chair. I will give you I plan on my questions moving relatively quickly because I have been taking notes, and I'm going to hit some areas that I think we have agreement, but I want to make sure that we understand that. As to the question with physician-owned businesses, it has seemed to me like all three groups kind of focused on whether or not a physician can own a dispensary is the Stark requirements, basically the self-referral problem. If a physician owns a dispensary, they cannot refer to themselves. Just like in every other health care, the reason it's not federally legal is because as of now there's no Medicaid money. If you do that in any other physician-based business, you go to prison. So have we kind of circled around that agreement?
Yes, absolutely.
Yes. Awesome. That makes sense. Good. As to the zoning issues, it appears to me we kind of circled around the idea that, and make sure I'm saying this correctly, we're okay with zoning requirements being applied. What we are not okay with is maybe the legislature needs an express prohibition to what I think is included in 788. You can't use your zoning requirements to completely take dispensaries out of a city.
Correct.
You can't use them as a sword.
Correct. Right.
Yeah.
Yeah.
Is that we hit the I want to hit a little bit of the money going into the industry because I want to make sure everybody has the same expectations. Is there an expectation that medical marijuana, and I'm warning you ahead of time if you say yes, I'm going to challenge you on some numbers. Is there an expectation that medical marijuana under 788, the way it is drafted now, will be a large boon to, for example, education funding in the state of Oklahoma?
Absolutely not.
Are we all in agreement in that?
I would just again go back to what I said earlier. The boom isn't going to come from the tax revenue, but it's going to come from all the supporting industries that will be creating a boom.
Absolutely. And Mr. Cavanis, I totally agree with that. And I want to make sure, because we had some questions, so we're on the same way, on the same wavelength. I'm not hitting the economic benefit of it, but from the standpoint of where the dollars flow, that at the way it stands now, we don't anticipate, and I think there's agreement there. Then as to the PMP, I guess this is my first question. The PMP, there were some questions about whether or not they should use the PMP because it is a Schedule I drug. You had brought up, Mr. Durbin, an issue I actually agree with you, but I lost the day on the PMP. I thought the PMP should have been done at the pharmaceutical level, not at the physician level, but I lost that issue, and it is done at the physician level. I will tell you, I have some concerns with using the PMP at the pharmacy level for medical marijuana, because we're dealing with privacy issues, and that right now we don't open up at that, even though I think it's how we should have done it. Again, I'm the legislature. When I lose, and I move on. Would it make more sense, instead of using the PMP, to use some other system to track?
Chip Paul, Oklahomans for Health. Absolutely, yes. And again, here's the community is concerned about this. The community is concerned about law enforcement accessing these databases or other entities. And I'll give you a great example. And again, I'll make this brief. But Hawaii had someone access their patient database and basically try to take firearms away from medical marijuana cardholders. They lost the challenge, but it was, we don't want law enforcement in that database. I think that's a very important thing to our community. So.
Is that kind of uniform?
Yes, Representative Ackles, Bud Scott, New Health Solutions. Yeah, most of these patient registries in other states and what we've set forth in the proposal, and there's plenty of models for this that are very functional, that have access for physicians, for the regulators, and just to make sure protect the patient safety. But I think a major concern is about federal law enforcement access to this as well, because I think regardless of how our state law enforcement or local law enforcement may consider this issue, it's a very different subject at the federal level.
Okay, I just want to throw it out there before we went too deep down that road. The next issue I want to get, that I'm a phrase in the form of a question, but in the form of a little bit of a politely pointed question. Most of you guys on that panel are my friends, so some of this is going to be, and if you're not my friends, only because we haven't known each other long enough. So no enemies over there, but it's going to be a little pointed. All three of you have said, and I 100% agree, that all three groups, that we need to move towards creating essentially a cannabis commission to be able to do everyone. Everyone has said that. To my knowledge, there is a cannabis commission laid out in New Health Solutions, which I'm assuming you're going to be okay with for you. But I want to know if you all want one, which I'm 100% in agreement with. Is there other options on the table, or what do you want it to look like? Because it's time to drill down. So let's drill down for a second. So that's my question.
Chip Paul, Oklahomans for Health. Absolutely. I think that, if you look at where the industry goes 2 years from now, and how do they affect change or, get something done, you really don't want them coming here. I mean, you really don't. You want them, and we probably, frankly, don't want them coming to the Department of Health. We want a regulatory commission that can deal with industry issues and move fast. And again, if recreational marijuana happens, how are we going to merge those programs? How are we going to regulate those programs? That's the perfect stuff for a regulatory commission. But I think here's a very important thing. That commission, 100%, has to have representation from our community. It's not going to be, and I don't think we'd be very supportive of a 100% governor-appointed commission. It has to have representation both from the activist community and the cannabis industry. And again, if we build a proper regulatory committee, isn't that what we want? I mean, if you're building a committee to regulate insurance, you're going to have insurers on that committee, correct? So that would be the thing that we would look for proper, setup.
Makes sense.
Ron Durbin, Green the Vote. In what we proposed and we provided you, in Section 11, we set up a medical cannabis advisory board that's responsible for, taking these issues. I think that a subset of the Department of Health that has the authority to propose things and that the Department of Health could only consider those things that came from this advisory board would be an ideal situation. The board that we proposed is made up of patients, advocates, caregivers, both adult age caregivers and caregivers who are taking care of patients who are under the age of 18, and then 4 medical professionals in various areas that we suggested. I think you need to have a wide-ranging and encompassing board that's going to deal with all the issues that we kind of mentioned earlier. There has to be an ability for a regulatory agency to deal with the majority of these issues. These are regulations, not statutes. And if you look at New Health Solutions, the reason why theirs is so long is the majority of it is regulations. They just put it in one form. I think if you carve out all the regulations that should be regulations from theirs, it's about the same length as ours. That's the way this should be done. You regulate the framework through statutes, and then you let the regulatory agency get in there and define the nitpicky things that need to be addressed. And you need a board that kind of widely encompasses and can have advocates on the board and doctors, and everybody can disagree and argue to come up with the best solutions. Compromise, as one of the people mentioned, is the only way that this is going to ever work.
Okay.
And Representative Eccles, thank you, Bud Scott, New Health Solutions, and thank you for the endorsement there, Mr. Durbin. One of the issues with our legislation and the reason we did put everything in here was because we saw the nature, the tight timeline here, and recognizing the issues that the health department has with no enabling authority to actually enact this program. So we tried to put this in statute so we could get this program going as soon as possible. Now, the medical marijuana authority and the structure that we've set forth includes mandatory patient representation, representation from a variety of facets of the industry, and then effectively gubernatorial appointments through the Commissioner of Health, the Commissioner of Agriculture, and the President of the Medical Licensure Board, or a physician that has 5 years experience and participates in recommendations.
Yeah. So I'm going to recap what I heard, and I told you this part that's going to be pointed, but pointed is friendly, by the way. Do you have something, Mr. Moe?
Yes.
Yes, sir.
Chris Moe, Green the Vote. I just want to, well, you're probably about to point this out. There's a theme here, and it doesn't involve law enforcement. As somebody who went through 3468, and that had a cannabis commission in it, a board of 12, I can't remember if it was 4 or 6, but a great deal of them were different law enforcement, and that's not what needs to happen in this situation.
So thank you for that, Mr. Moe. What I want to point out, what I've heard from the three of you as I understand it, and I would actually submit that all three of you are not saying something that's in conflict. And what I hear is we want the right advocates on the board. What I hear is that what I thought your response would be, which I like, you want to take your advisory committee and turn it into a commission, which is kind of the same thing, which I think is a great idea. You've hit Mr. Paul's perspective. What Mr. Scott has laid out is once we make your advisory committee a commission, who picks them? How are we going to get that thing down? This is just like every other statute we have. The point I want to make in my next few and there's a reason I did that. That is, by the way, probably the biggest issue we have to deal with. Whatever we do, the creation of that commission, if we could find a way, Mr. Durbin, you said some things that I agree, and I took them as good-natured shots, but I'm going to rib a little bit good-natured right back about the legislature has a tendency to go too far or to do special laws, and I kind of agree with you on some of that. But I hope what you guys just saw is part of the issue and part of the problem we're dealing with right now. You all three want the same thing, and frankly, if you could have found a way to talk together beforehand, you probably could have had it, because you're all three asking for that. It's difficult for this committee when I go to them and talk to them and say, you know, who, by the way, does want to do the right thing, does want to, it gets late, that's why some of that happens, and I think maybe some committee members can be snippy and everybody, so it's no big deal. But I'm not saying that in any way, and I'm trying to choose my words so carefully that you understand they're said from a friend who believes that there's that opportunity here for us to do this. And I'm going to hit that in a couple other questions, and then I'm going to have an ask of the three of you guys at the end. I'm a politician. I'm used to having asks of me. I'm going to make one of you guys. You talked about board-certified physician. I only have two other issues, and we're going to come back to you. Talked a little bit about board-certified physician. I have a couple doctors, Mr. Paul and to Mr. Durbin and to Mr. Scott. I want physicians licensed in the state of Oklahoma, but that don't actually pay to be part of a board to be able to participate in this program. But I don't know how to do it under the language. Help me. Or tell me that I'm wrong and that that's not what it should be.
Ron Durbin, Green the Vote. I think you can already do it under the language.
Right.
It says board certified. The state medical board certifies that they have met the requirements to practice as a doctor in the state of Oklahoma. That's a board that is certified. That is all that is required. Now, whether they're a member of the osteopathic board of whatever, no, I don't think you have to go that far. It's all a question of how far you want to take it. Don't take it that far. Say they are licensed in the state of Oklahoma to practice as a doctor and a physician, and that's good enough. Or say that they are a doctor that's also licensed to prescribe narcotics. Maybe that's one thing you want to require because they have experience dispensing controlled substances. Not a bad idea, but that's all you have to do.
To Mr. Durbin's point, I would completely agree with exactly what he just said. So if you're licensed to practice medicine in the state of Oklahoma, that's exactly what we meant.
And Representative Eccles, Bud Scott, New Health Solutions, we actually included very specific language on this that came from feedback from several physicians and others in the community that had problems with the board certified language that was included. So it removes the actual board certified portion of that, makes more reference to licensed physicians, because board certification, when it's taken in the context of discussing specific medical practices, is usually done by a national board rather than a state licensing entity.
Ron Durbin, Green the Vote. The only thing I would say with regards to going to licensed is you're going to pick up every medical resident that they're licensed as a doctor in the state, so you be careful there.
But Scott, except we specify residents are not under that definition.
Representative John Eccles, see, you guys can't agree when you talk together. And as the last question I have is kind of the hard one. So we have talked a little bit, and I want each of you to have time to answer this because this is kind of the big one. There's been a lot of talk of limiting licenses. I don't know that anybody is talking about that now on the committee. I can't speak for the committee, but I don't know that anybody is looking to limit that number. There are some issues the committee is dealing with in what is the proper mechanism, if anything, because everything else in healthcare, you have some level of a requirement, whether it's just a demonstration of capital, it's as simple as that, whether it's here's where your money came from, if you want to open a home health, if you want to open a hospice, if you want to open a pharmacy, there is some level that you have to comply with. Is there any level that is appropriate? Is there anything? Should we require people to disclose where their money comes from? Should we require people to disclose that they have enough money to run whatever it is they're asking for? And that's the real hard question that I want everybody to have an opportunity to answer. And if we don't do that, my concern, and I don't know that I'm there that I want to do it yet, but my concern with all of that is it would then be the only thing in healthcare that we don't. So what are the possible problems there? And I'll leave that open to again, I saved my hardest question for last, so I'll leave it open to everybody.
Isaac Cavness with Green the Vote. From my perspective, I would fall more on the side of liberty, and just because we do it in one area doesn't mean that's the right thing to do and that we should continue to do it. I understand that there is a thought process of trying to make sure that people are going into the business who can actually afford to go into the business. I was raised in America where we can dream big and we can make that happen, and by preemptively putting income limitations, funding limitations, stuff of that sort, That's taken that dream away from the little guy, and that's where I've been my whole life. Is I've been a little guy, and that's who I represent. And these types of means tests, although can be protective to the little guy because you're trying to say, no, you don't have enough money, you shouldn't be doing this. Well, that little guy might surprise you. He might be the guy that can take a couple of $1,000s and turn it into a couple of $1 million. That's not our place to stop him. Don't stop me.
Ron Derman, if I could add, one thing to it, I would urge you to go look at the application that the ABLE Commission has, and actually read through everything that is required on that application, financial disclosures, the questions that they ask. We have created a system in that regard that is so overbearing and almost impossible to get through with the number of agencies you have to go through to report this to the tax commission, the ABLE commission, the state health department, county health department, the city for permits. We have created such a regulatory scheme and required so much information that nobody ever uses. It's created a pointless system that is impossible almost to get through. And the businesses that are in it have figured out how to get through it, but it's an arduous task. What we don't want to do here is to create a system where there's capital requirements and the ingenuity and entrepreneurial spirit of an Oklahoman is fettered because they don't have the same kind of capital requirements. Because once you start requiring that disclosure of capital into their business, then what you invite is regulations to restrict people who have too little. There's no reason to do that. If they don't have enough money, their business is going to fail. If they don't have the ingenuity and the work ethic, they will fail. Let them fail because of their own efforts, as opposed to not even giving them the opportunity because you put some capital requirement or some financial disclosure requirement or insurance requirement on them that precludes them from participating in the market.
Chris Moe, Green the Vote. I'd just like to add to that just a little bit with a slightly different twist. I think anybody with the $2,500 and $1 left over to buy a bud ought to be able to go into the business. And let me tell you why. Because if you stop them, a great deal of these people are going to do it anyway, and that's where your black market comes from. So you want to eliminate the black market, I have plenty of ways to do that. One of them, as I've said before, is giving the home growers somewhere to go with their medicine. Another one, as we say, is to make it easy to get a business license. If you fail, you fail. That's America. It's not your job to protect us from failing. It's just your job to keep everybody safe and stay out of the way.
And Representative Eccles, Bud Scott, New Health Solutions, Oklahoma. I think this issue was one of the most controversial portions of our initial proposal on this, of having a demonstration of adequate capital to the tune of $25,000 of liquid capital. All of those caps have actually been removed from this proposal. They're specified in sections, excuse me, they're specified in section 24. However, we're still talking again about a Schedule I narcotic, and we're still talking about medicine. So there does need to be a demonstration of where your funds come from, and this is a well-developed policy that comes from several other states to prevent the proliferation of cartel and illicit funds in this industry. And also it helps to identify the truth and ownership, like we just discussed a moment ago about out-of-state interest having the ability to basically circumvent any laws that would keep them from surpassing that 25% rate. So the only way you do that is through a CPA-attested financial disclosure form.
Liberty. Everybody deserves the right to fail. And as bad as that sounds, again, we set this up for every Oklahoman. We did as a business. And, we talk about all the time, how do we protect the little guy? We talk about that in our trade organization. We talk about that amongst ourselves. So in the industry, I think we'll have some mechanisms to do that. But again, in our minds, we're dealing with a natural product here. It needs to be regulated, but let's have appropriate, liberty is the most important theme here. It's we the people, so.
Well, thank you guys for that answer and the seriousness of you being here today. I'm going to open up if there's any other questions from the committee. Representative Loring.
Thank you, Mr. Chair. One of the things we haven't talked about is somebody that's passing through the state that has a medical marijuana license from another state. Now, I know in 788 we address a temporary license that a person can acquire. As a practical matter, what are the logistics of doing that? I mean, you're not going to issue them at every welcome center.
Isaac Havness, agreeing the vote. I was actually pretty surprised when I went back and read 788 that it put that requirement in there. I think if we could go back and fix that, that might be an area that we might consider fixing. If I could just wave a magic wand and make it happen, I would say that the state of Oklahoma should be able to recognize these out-of-state cards without requiring them to apply for a special temporary card. So, you know, that would be my hope, just like a driver's license, that when you cross state lines, your license would be good for you to travel through that state. But I understand 788 specifically calls for a temporary license to be granted, and I certainly would not oppose that being changed myself, but I'm sure Chip has an opinion on it.
Yeah, so Chip Paul, Clements for Health. When we wrote that legislation, that was in 2016, and in 2016 I believe there was one other state that allowed, they call it I can't say the word, reciprocal licensing, right? So one other state allowed reciprocity. I did it. Yeah. But we wanted to tightly define that. So again, you know, the intent there obviously is if you're a medical patient in Arizona and you come to visit family or whatever in Oklahoma, you should be extended those same, you know, rights by virtue of our program, and that's what we're trying to do. I would agree with Isaac. You know, by now the medical programs, you know, pretty much around the country, and even California is getting there, are tight enough where we could probably just allow someone else's card, but we were actually trying to prevent, you know, abuse and black market and people making their temporary cards and, you know, coming in that look like other state cards, like they do temporary IDs. So we wanted some registration process, a little bit of formality. So someone's going to have to think ahead about a month and apply and do those things. That was the intent.
Follow up? For a follow-up?
A slightly different, well, it is a different question. I'm just as concerned about those Oklahomans that don't want to be exposed to marijuana or their family to be, and I talked with Mr. Durbin last week about this. In Oklahoma, we have the smoking, it's Title 21, Section 1247, which prohibits smoking in certain public places. But it only prevents smoking, and it very specifically says tobacco. It does not apply to vaping, and it would not apply to this. Does anybody have any objection? Help me out with this. So, can we expand that to cover vaping and cover marijuana? Does anybody have an objection to doing that?
Ron Durbin, green the vote. In public areas, absolutely not. Or restrict, I mean, vaping is, in my personal opinion, I hate walking through a cloud of the vapor that somebody just let out. I think the same thing applies. So anywhere you would restrict somebody smoking in public, restrict vaping in public, because it creates the same kind of situation that we're trying to move against and away from. So we have no problem with that in public places.
Chip Paul. Chip Paul, Clements for Health. One of the things so I agree with what Isaac just said. He said, but only in public places. And again, you should have the right to do that in your home or, you know, privacy, right? So we are firm on that. But one of the first things that we did, it's funny, when a group of us went and met with the Department of Health before all the fiasco and everything, one of the first things that we all agreed on is to respect, you know, the Oklahoma state no smoking laws. And absolutely all of us agree with that 100%. And I believe those, and again, I'm not, you know, I don't live in your world every day, but I believe those do extend to vaping. I don't think you can, okay, so we would, again, be supportive of that extending to vaping. But again, that's not, the intent of our law wasn't to regulate vape, clearly, but.
Ron Durbin, Green the Vote, if I could, real
yeah,
quick.
you can.
And I can't necessarily say that Green the Vote agrees with this personal opinion. I would restrict I would include public places to be any place that there's public, like, for example, you can have a smoking bar that's not subject to that. I would say that in a public place like that, there shouldn't be any smoking of it or vaping of it. That's a personal opinion. It might not necessarily reflect what Green the Vote thinks, but it seems to make sense and is consistent with the smoking laws, with that one exception of bars can still allow smoking, which to me probably should be addressed too.
For a final follow-up, then I'll get back in the queue.
Thank you. So just to make sure that we're all on the same wavelength, you wouldn't have any objection to changing the non-smoking laws to include marijuana, because they very specifically say only tobacco products, and to include vaping in those places like at a restaurant, movie theater.
No objection from
Basketball
us.
game.
Absolutely no objection. So we would agree to that.
Representative Loring, Bud Scott, New Health Solutions, Oklahoma. We've included that language in our proposal.
Thank you, Representative Fettgetter. You are recognized for a question.
Thank you, Mr. Chairman. I'm just curious, can you tell me what the yield is annually for a mature plant?
Well, Ron,
Chris Moe, Green the Vote. How long do you have? If you go to my page, you'll see me, and they call me Uncle Grumpy, by the way. You'll find my page. I'm standing next to a 12-foot plant. That's in California on a legal farm. That plant put off around 11 pounds. Most people in Oklahoma that grow their own are going to grow more like a half ounce, 3/4 of an ounce, maybe an ounce and a half.
For a year?
Per plant. You said per plant.
Yeah, annually.